Okay, so I'll just introduce myself again. I'm a member of the Mohawk Nation of Kahnawake. I'm a policy analyst. I've got about 30 plus years of experience working at the community level with regional organizations. I worked for the National Indian Brotherhood and Parliamentary Liaison back in 1981. And I worked for the Assembly First Nations twice. Once as a special projects coordinator for what they called the bilateral process, which was on the federal First Nations relationship. And I was Indian Act Amendments coordinator for the Assembly First Nations back in 1996, 97. So I do have experience analyzing legislation. We stopped the Indian Act Optional Modification Act, Bill C-79, back in 1996, 97, because it was more regressive than the status quo. And then we also stopped the First Nations Governance Act, which was basically a repackaging of that Bill C-79 from the bureaucrats. So let me just go through. I've done a few slides I thought we could go through just to make sure I remember the points I was going to make. Okay, so basically, I just wanted to start with reminding people what is the UN Declaration on the Rights of Indigenous Peoples. And I recommend this book, Indigenous Nations Rights and the Balance and Analysis of the Declaration on the Rights of Indigenous Peoples by Charmaine Whiteface. It's an excellent book. It covers the UN Declaration and the changes that went through in the United Nations. I selected, there are 46 articles in the UN Declaration. Some of the ones I've highlighted here are the ones
Russ, we're not viewing your slides. We're seeing your desktop.
Really?
Did you click on,
Hang on.
Yeah, there you
So that's what you're seeing is this screen, right?
Yeah, we're seeing your desktop, and it has the, we see you highlighting over top of your slideshow, we see your cursor over top of the slide deck. And if you click on it, it should open it for us.
Yeah, I did click on it. Can you see it?
No. I'm not sure why. Do you get an option to choose which of the windows you have open that we want to view?
I'm just going to look and see.
Because the other thing is, if you want to send it to me through the chat, if we can't make this happen, I can post it up and I'll just move the slides as you tell me. There it is. Okay, we got you.
Okay, so I'm going to try again.
Yep.
No, I don't see it here. Sorry about that. I'm not.
We'll work it out. This is why we can't wait for COVID to be done, and we can do this stuff in person again, the way we're meant to do it.
Okay. Let me see if I can find the option now.
So when you click on
Oh,
on
okay, I
share
found it.
good. Okay.
Now do you see it?
We're still on your desktop. Why don't you flip it over to me real quick and I'll load it up and put it up.
Okay.
Do you want to just send it by, just attach your file to the chat?
I guess I can do that if it works. Let's see.
Or if it's easier for you to just email it to me, I can open up my email.
Chat.
So in the chat, you can just click file and you can attach the file from your computer.
Oh, yes. Okay.
Great, thanks. So it's just going to take me a minute to open it once it's loaded. Okay, now I'm going to go to share screen. And then I'm going to go can folks see that now? And then I'm going to slideshow. Are folks able to see the slides? Russell,
Yeah, they say they can see it.
I'm going to, you just tell me when you want me to flip the slides.
Okay. So I wanted to start with, what is the UN Declaration? Can you go to the next slide? And I'm encouraging everybody to buy this book. It's an analysis of the Declaration and the various changes that went through at the United Nations, because it was changed from the original version that Indigenous people supported in the 1990s. And she does a side-by-side analysis of the text and which sections were changed into which versions. Next slide, please. So there's 46 articles of the UN Declaration. I've highlighted some of the key ones here. I think the most important one in the UN Declaration is Article 3, the right of self-determination, because it confirms that Indigenous peoples are connected to the international covenants on civil and political rights and education, social and cultural rights as peoples. Article 10 is important, no forced removal without free, prior, and informed consent. Well, in the Wet'suwet'en situation, we've seen they violated that article in BC. Article 19, free, prior, and informed consents required before legislative and administrative measures. I didn't include Article 18, I should have, because Article 18 says that Indigenous peoples have the right to decision-making through their own Indigenous institutions and their own Indigenous procedures. And bands and band councils are colonial bodies, they're not Indigenous institutions. And band council resolutions are not Indigenous procedures. But the government's focusing on Article 19, which says that Indigenous representatives need to be involved in any legislative or administrative measures. So that's how they're getting by using AFN and the other organizations. They're ignoring Article 18. Article 26 is important because it talks about Indigenous peoples have the rights to lands, territories, and resources that they traditionally used and occupied, and there should be restoration. Article 27 says there should be a fair process jointly developed to adjudicate rights to lands, territories, and resources. We've never had a say in the land claims policies. Some say in the processes, but not the policies. So Article 27, talks about jointly developing that process. Article 28 says if there's not going to be restoration of lands, territories, and resources, there should be just, fair, and equitable restitution, either in the form of comparable land quantities or monetary compensation. And Article 32 is explicit about free, prior, and farm consent being required for any development affecting lands, territories, and resources of Indigenous peoples. And the federal government's watered that down in the so-called 10 principles on Indigenous relationships. Principle 6 says the federal government will aim to get free, prior, and farm consent. Meanwhile, Article 32 says states shall obtain the free, prior, and farm consent from Indigenous peoples for any developments affecting their lands, territories, and resources. Of course, Article 37 talks about treaty rights, agreements, and other constructive arrangements. They added in agreements and other constructive arrangements, but there was a treaty study done by the United Nations, which talked about the importance of the international status of the treaties. And then Article 46, which is a problem. None of the premiers who are opposing this bill mentioned this article, but Article 46 says nothing in the declaration can be interpreted to challenge the assumed sovereignty or territorial integrity of the state. That's not exactly the wording. I added the word assumed sovereignty because Canada has assumed sovereignty and territorial integrity of the state based on the doctrine of discovery. So I just wanted to make sure that we understand, what are some of the key articles of the UN Declaration before getting into the draft bill or into the bill. Next slide, please. So it's important to realize that the UN Declaration was watered down first at the United Nations. There were 3 drafts of the UN Declaration. The first was the original text version in 1994 that Indigenous peoples from around the world had a lot of input into, as well as legal advisors. That was the version that there was broad Indigenous consent to. But an official in the UN amended that version in 2006, and that became the Human Rights Council version. And the final version of the UN Declaration was passed by the General Assembly resolution in 2007. But at the last minute, there were other changes made by the African Union, specifically Article 46, about nothing in the declaration being able to challenge the sovereignty or territorial integrity of the states. Those changes were never presented to Indigenous peoples when that declaration was adopted in New York City. And it's the first original text version of the UN, like I said, that was drafted by hundreds of Indigenous representatives over a period of years with their direct participation. And that was subsequently undermined by, politicized negotiations within the United Nations. Next slide, please. So this bill C-15 was introduced into Parliament on December 3rd, only after a 6-week, what they call engagement process. And it was selective. It was basically bypassing the rights holders, the Indigenous peoples and nations. And even in Canadian law, the courts have recognized that the rights holders are the people themselves, the Indigenous peoples. But instead, the government focused on organizations which they fund, like the Assembly of First Nations, the Métis National Council, the Inuit Teperis, Kanatami, to manufacture consent. And this is a continued violation of the right of self-determination. And this manufactured consent, really brings disrepute to the process and the people who've cooperated with the oppressor, the government of Canada, who's dominating throughout this whole process. Next slide, please. So I just want to walk through, what is in the UN Declaration Bill C-15. Next slide, please. So it's a proposed federal law. They introduced it into Parliament December 3rd, 2020. First thing we should know is the preamble of the bill is not legally binding. It's used to interpret or give context to the operative sections of the bill, but the courts will focus on the main sections of the bill, not the preamble. So we've been telling our people, don't get distracted by the preamble, which is what advocates of the bill keep pointing people to, is the preamble and not the main sections of the bill. So Section 1, the title of the bill, it's cited as the United Nations Declaration on the Rights of Indigenous Peoples Act. This title reflects the intent of the bill, which is not to adopt the UN Declaration and the laws of Canada. Otherwise, in our opinion, Bill C-15 would have been titled the Adoption of the UN Declaration Act, or a similar title. Section 2.2 on the rights of Indigenous peoples, we have really big problems with this section. It maintains the common law interpretation of Section 35.1 and 35.2 of the Constitution Act 1982, which again is heavily based on the colonial doctrine of discovery. In our opinion, nothing will change if this bill becomes law. What we call White Paper 2.0 will remain the same. And I'll get into that a little more later. Section 4, the purpose of the act, again, it's merely to affirm the UN Declaration, but it does not adopt or approve the UN Declaration to be implemented in the laws of Canada. And Bill C-15 does not respect the international standards of law, which require things like free, prior, informed consent and recognizing self-determination. The whole process to develop this bill violated all of that. The next slide, please. Section 5, measures for consistency of laws with the UN Declaration. We've had lawyers look at this, and their opinion is the court could not order the government of Canada to adopt legislation that conforms to the UN Declaration based on the wording or text of this section, nor could it invalidate a federal law for being inconsistent with the UN Declaration based on this section of the bill. Section 6, the action plan. This section of Bill C-15 gives the government of Canada a dominant role in interpreting the UN, what they call principles instead of standards, in relation to federal laws, since under Canada's constitutional division of federal and provincial powers, the provincial governments have a veto in subject areas that affect their jurisdiction, like over lands and resources, for example. Section 7, reporting to Parliament. Bill C-15 in its preamble or in this section makes no mention that the government of Canada is preparing and implementing an action plan that they shall obtain the free, prior, informed consent of Indigenous peoples and nations in accordance with their own procedures and their own Indigenous decision-making institutions, which again is in Article 18 of the UN Declaration, that wording. Instead, they talk about the consultation and cooperation with Indigenous peoples in developing the action plan and in reporting to Parliament. Next section, please. Next slide. So from our point of view, the impacts of Bill C-15 are that they're basically copying what the BC government has done. This is a government bill, same way as the BC government had Bill 41. And they used a top-down approach in adopting that BC UN Declaration law over a year ago. There's a BC First Nations Leadership Council that worked with the BC government to adopt the BC UNDRIP law, Bill 41. And that Leadership Council represents the main chiefs organizations in the province. But there are 203 Indian Act bands in BC whose band members were not consulted about Bill 41. And many of them likely still don't know the implications of what that UN Declaration law are yet. Similarly to Bill 41, if C-15 becomes federal law, it will negatively affect all aspects of the lives of Indigenous peoples and nations in Canada for generations to come, because the bill will keep in place the colonial system of the Crown's federal, provincial, municipal, centuries-old domination through its laws, including the Constitution Act 1867 and the Constitution Act 1982, which are based on the colonial doctrine of discovery. Next slide, please. So the main sections of C15, especially Section 2, maintain this common law interpretation of Section 35 of the Constitution. As I've said, it's heavily based on the colonial doctrine of discovery. Can you hold on 1 sec? Sorry, I have to pause. Sorry, I had to unlock a door. So the application of the doctrine of discovery has resulted in a number of problems in legal interpretations and case law based on Section 35 of the Constitution Act 1982, which negatively impact on the ground daily life for Indigenous peoples and nations in Canada. You know, the Supreme Court of Canada, the so-called Apex Court, has interpreted that Crown sovereignty trumps Indigenous peoples, including self-government rights, although they haven't explicitly ruled on whether self-government's an Aboriginal right or not. Through various case law of interpreting Section 35 over the past 30 years, they've disregarded Indigenous laws and legal traditions in favor of Crown sovereignty. They've established the Crown has ultimate title to land. You know, that was in the 2014 Chilcotin case. They said the radical underlying title belongs to the Crown. The Supreme Court of Canada has placed the burden of proof on Indigenous peoples and nations to establish their rights in Canadian courts. The racist and frozen in time Vanderpeet legal test for establishing Aboriginal rights is being maintained by this interpretation of Section 35. And Vanderpeet was a case involving the Stolo Nation in around Chilliwack in BC, where they were arguing they had the commercial right to trade in fish. And the court said they failed to prove that, and they set out a test saying anybody who asserts they have Section 35 Aboriginal rights has to prove that it was a custom, practice, or tradition they did prior to contact, and it has to have survived contact into modern times. And that's a really high threshold to meet. You know, it costs millions and millions of dollars to collect the historical and cultural information or evidence to meet that test. And also, you know, it maintains the ability of the Crown to infringe Aboriginal rights based on the Sparrow legal test. And Sparrow, again, was a fishing case in BC, the first case interpreting Section 35 in 1990. And it had to do with the Musqueam fisherman saying he had a Section 35 right to use a net bigger than the Department of Fisheries and Oceans regulations allowed. And so that went all the way to the Supreme Court, and the Supreme Court said Aboriginal rights can be justifiably infringed for valid legislative reasons. And they set out again that, you know, conservation, priority Aboriginal use, public use, kind of a hierarchy of rights in that case. And then also Section 35 has been interpreted, you know, and if Bill C-15 passes, it'll lead to the erosion of the government's duty to consult and accommodate to nothing more than a procedural right that's reviewable based on administrative law principles. So, you know, sorry, go back, please. So to understand this, you have to understand that the so-called duty to consult that the Crown has laid out results in on the ground that Indian Act bands get these consultation requests mostly from the provincial governments. If they want to do a development on a, you know, traditional lands or territories of Indigenous communities and nations, the community has to respond to the consultation request with some evidence to say how will the project impact on their rights. And so anything they send to the provincial ministries or departments has to go through what they call strength of claim analysis, where they apply these Supreme Court of Canada tests to determine if the right that a community has is a weak right, like just having to require that they get a notice that there's going to be something happening, to the strongest right would be like showing they have the potential for Aboriginal title, to prove that they have Aboriginal title. Not that they've established it, but they have the potential to do so. And so not only is there a strength of claim analysis, but there's a depth of consultation analysis which goes along with that. If it looks like they have a strong strength of claim, like potentially being able to prove they have Aboriginal title, then there's an accommodation approach where either they talk about changing the project or activity, giving compensation for it, or some other kinds of compensation. So this is the impacts of maintaining the Canadian domestic law approach, or the Canadian definition of under Section 35 of the Constitution, is it maintains all of these Section 35 court cases. And originally, Section 35 was supposed to be a political agreement with the national Aboriginal organizations. They had a Section 37 process when the Constitution Act 1982 was adopted into law. And that led to those first ministers' conferences on Aboriginal matters in the 1980s. But Section 35 is unfinished business because that process was supposed to identify and define the meaning of Aboriginal treaty rights in Section 35. But the governments ran out the clock on that process and it ended in failure. Then the Supreme Court took over to interpret Section 35, and that's what's listed here is the court cases they've issued to limit and restrict Aboriginal treaty rights over the last 30 years. So rather than evolving to respect international law, the C-15 is going to entrench and interpret the UN Declaration under Canadian domestic law through Canadian definition. That's why we call it CANDRIP, not UNDRIP, the Canadian Declaration of Rights of Indigenous Peoples. Next slide, please. So, the Trudeau government's co-opted our terminology, since 2015, nation to nation, reconciliation, decolonization. And over the last 5 years, the Trudeau government's operated in a secret top-down manner using, the Assembly of First Nations and the other national Indigenous organizations to give the appearance of co-development of massive unprecedented changes to policy, law, and structure. I haven't gone through all of that, but, there is a chronology I put together to show what they've done over the last 5 years on changes they've made without consulting the rights holders on the ground. And in 2018, the Trudeau government stated it was delaying a rights recognition framework bill that it wanted, that it in 2018, on Valentine's Day, I think it was, the Prime Minister made a speech in the House of Commons and saying he wants to have a law passed before the next federal election for a rights recognition framework. So in the fall of 2018, they announced, because it was rejected widely, the proposed bill was rejected widely by First Nations, they delayed it publicly, but privately what they continue to do is implement it in separate discussion and negotiation tables across the country. They have different categories. They have these recognition tables, modern treaty tables, self-government tables, and they have this alternative federal legislation. The First Nations Land Management Act, First Nations Fiscal Management Act. They have other laws they've passed too. So Bill C-15 uses the domestic policy law Section 35 framework developed over the past 5 years and earlier. And if Bill C-15 becomes law, that's going to be the framework to interpret and implement the UN Declaration's 46 articles. I think that's the last slide. Yeah. So that's why we object to it. They did not do any kind of a 6-week process during a pandemic is not consultation, let alone obtaining free prior informed consent. And that's why our networks, our 3 networks that form the Indigenous activist networks, object to Bill C-15, and we have a campaign to stop it. We don't think an issue this significant should be put into Parliament during a pandemic while our people are focused on their own survival. And the only reason the Trudeau government has introduced it is because they promised in their platform in 2019 that they would introduce a bill in 2020, and they promised it in their throne speech. But that's not a good enough reason. If they were going to do that, they should have started talking about it in 2019, right after the federal election. They should have, communicated with the communities. There's 630 bands in Canada. Just like in BC, there's 203. In BC, the Oregon government just bypassed all those communities, did a top-down approach. Trudeau has been doing the same thing, but that doesn't meet the international standard for, free prior informed consent or the right of self-determination. So that's why we oppose Bill C-15, and we're going to fight it. And we're organizing, to document our people's opposition to it. Probably using this technology like Zoom calls, because the federal government's negotiating what I call termination agreements with band councils using Zoom calls. The Assembly of First Nations, which has manipulated the process to deny a resolution to be debated at their Chiefs Assembly in early December. They're using this technology to make decisions. So that's what we're going to do, is encourage our people to use this technology, archive the calls, and also do written declarations confirming that there's no free prior informed consent from as many Indigenous peoples as we can get from the rights holders to document that as possible. And also we can use that to take it to the United Nations. The Committee for the Elimination of Racial Discrimination just wrote the federal government asking for them to present at a periodic report this coming November on this legislation and what steps they've taken to involve Indigenous peoples in developing this legislation. So we're going to get documentation to show that they bypassed us, and they're just using the funded organizations that they have to, basically manufacture consent. So that's what I have to say about the process and the content and the broader context that this bill, if it becomes law, will be interpreted in. So thank you.
Miigwech Nawa, Russ, for your informative presentation. Are folks on the call interested in asking any questions? If you'd like to ask Russ a question, you can unmute. I know that I got a few in the chat, so let me just see what I got. Curious what you have to say, Russ. Someone's posting here about C-262 and what's the relationship between Bill C-15 and 262? Well,
I never supported Bill 262. That was Romeo Saganash's private member's bill. I'm not going to spend a lot of time saying what was wrong with it because it's in history now. This is a government bill, not a private member's bill. And it has more significance, in my opinion, as a government bill. And the Assembly of First Nations, if you go to their website, they do a side-by-side comparison chart, a table of Bill 262 and Bill C-15, because the National Chief of the Assembly of First Nations, Perry Bellegarde, has been saying that he has a mandate to support this bill because his mandate is to get a government bill that is above 262, like the minimum ceiling above Bill 262. They're arguing they have that. I've looked at the AFN resolutions. I don't believe that the National Chief has a mandate to support this bill because it doesn't meet the conditions that previous resolutions that the Chiefs and Assembly have put forward. I'm probably going to do an article on that to document that. But he's not running again in the next election, so he's free to do what he wants to support the Liberal agenda. That's what he's been doing, in my opinion. That's why I ran against him. I don't see him changing that. I do note that Senator Lillian Dick from Saskatchewan is retiring. So there will be a Senate seat open in Saskatchewan soon. So I don't know if he's going to get that appointment or not. We'll have to see what happens between now and if there's a federal election called in the late spring. But I suspect he has another lily pad he's going to jump to. So we'll see.
Great, thank you. Another person is asking, what are the opportunities for pursuing this at the international level? Is there any recourse with the UN in terms of the application? Is there any opportunity with the international courts?
Well, we wouldn't have standing in the international courts, but we would have standing at the human rights bodies. And as I just mentioned, Canada is a signatory for the Convention for the Elimination of Racial Discrimination. That is CERD. There is a committee for the elimination of racial discrimination. They just wrote Canada a letter, basically criticizing Canada for proceeding with the Site C Dam in BC, the Coastal GasLink pipeline in Wet'suwet'en Territory, and the Trans Mountain pipeline in Secwepemc Territory. Saying that they didn't get the free, prior, informed consent of the Wet'suwet'en or Secwepemc peoples. But they've also asked about this bill, this law to implement the UN Declaration, and what role have Indigenous peoples played in developing the bill. So we have a forum there with CERD to document and show that Canada completely bypassed Indigenous communities and nations in developing this bill. I'm sure there are other ways that individual Indigenous peoples, communities, nations can make their own interventions at the UN to talk about how this bill, if it becomes law, will impact on them. So I'm sure there's opportunities at the United Nations.
Great, thanks, Russ. Another question that came in was, it seems that for some folks, there's a concern that this is a rare opportunity, best opportunity moment. And I know that you've heard that about other pieces of legislation. At the beginning of your introduction, you indicated where you've actually stopped legislation that had come into play before. Can you speak at all about your past experience in the movement, stopping other bills that community has felt have been fundamentally working against the effort to achieve the kinds of outcomes that most people are hoping to achieve with this particular bill? And so I guess the question is specifically, what do you know from past opportunities when Indigenous folks were faced with, this is 1982, this is your opportunity, 1996, this is your opportunity. The world is very different than it was in the 80s and 90s, and we've moved in a deeply neoliberal direction. And so for some folks, they see this as an opportunity to begin to push us in the right direction, and that we can improve it once we have legislation. That then, the way a bill works is you introduce the bill and it's very generic, and then the process of developing the legislation and the details of that follow later. Could you speak a little bit about your concern about this incremental approach and why your crew figures it's not the right approach for this particular bill?
Well, because if the bill passes, it's basically subverting international customary law and the standards or the articles of the UN Declaration underneath Section 35 and the interpretation, the Canadian definition of that under domestic law. And I just went through a list of the problems with for the past 30 years, the Supreme Court of Canada imposing legal tests and principles on us, interpreting Section 35 when Section 35 was supposed to be a negotiated political agreement to interpret the meaning of Aboriginal treaty rights. And in 1987, when those constitutional talks ended in failure, we should have had many leaders going over to the UN and complaining that Canada's new constitution was a denial of Indigenous rights, because they're unilaterally interpreting, what Section 35 means. Now, 30 years later, we can see what has happened with them doing that through their courts. And in my opinion, and in the opinion of others, the Supreme Court of Canada and the courts are in a conflict of interest because they base their authority on the doctrine of discovery. In fact, like I said, in Chilcotin, they said the radical underlying title belongs to the Crown and that Aboriginal title is a burden on Crown title. Well, we don't see it that way. We see Aboriginal title as the underlying title and the Crown title, the assumed or asserted Crown title, is a burden on our title. And in terms of international law, we have an international right of self-determination. We have land rights. We have the right to free, prior, informed consent. These are all minimum standards set out in the UN Declaration, which they're undermining by trying to interpret the UN Declaration through Bill C-15 to make it subject to all of this case law the Supreme Court has put forward rather than international law. And, previously, we don't really like the Indian Act, but when you see a bill like, in 1996, Jean Chrétien's government, Ron Irwin, the Minister of Indian Affairs, came forward with this Indian Act Optional Modification Act. It was worse than the status quo because it was imposing more control and management by Ottawa bureaucrats over all of our communities. And so we recommended to the chiefs that they reject it. And we had to do plain language analysis of the legislation or the bill. And they agreed with our assessment, and we fought against it, and it died on the order paper in 1997 when a federal election was called. But, we have to remember that the bureaucrats are the permanent government in Canada. Regardless of who the politicians are, the bureaucrats just keep recycling their ideas on how to control and manage spending over First Nations or Indians. And so they always want to have better control through legislation and regulations. And they have passed laws to promote those ideas. So the First Nations Governance Act, that was a repackaging of the Indian Act Optional Modification Act, again under Jean Chrétien, but under a different minister, Ron Irwin. What was his name? Robert Nault. I've been through so many ministers. Robert Nault, and we got that stopped with the help. Actually, with both bills, we got the support of the NDP and the Bloc Québécois and helping us slow those bills down until we could get them stopped. Now, this time around with Bill C-15, we're pretty sure that the NDP are going to support it with the Liberals because they've been propping up the Liberals. Romeo Saganash, being a former NDP member, they're going to support it because of Bill 262. We're sure the NDP caucus will be doing that. But the Conservatives are against it, and they've been putting out there against it. 6 premiers, Conservative premiers, have come out and said they're opposed to it because it happened too fast. There was no consultation with them. Like I said, it was a 6-week process. So they have some legitimate issues there in terms of the time that it was rammed through. But the issues I have with the Conservatives are that they're focusing on FPIC, whether it's a veto or not, and the implications of that on resource extraction in the provinces. But what they're not referring to is already, the UN Declaration, which is not legally binding, but it does have Article 46 in it, which says that nothing in the Declaration can be interpreted to challenge the sovereignty or territorial integrity of the state. So, already Canada's doing all this, relying on Article 46 to basically say they can do what they want. The late Art Manuel and I talked about the UN Declaration. The reason why we say Article 3, the right of self-determination, is the most important article, because the right of self-determination is the remedy to colonialism. And we think that's the counterbalance to Article 46. And the issue really becomes the lands, territories, and resources, and free, prior, and consent over them. When Canada said they were going to give unqualified support for the UN Declaration back in 2016, Carolyn Bennett said that at the UN. The next sentence she said, in accordance with the Canadian Constitution. So right away, you're into the constitutional division of powers where, they continue to dominate. And the only room they're giving us, Trudeau referred to Indigenous governments in 2016 as the fourth level of government. After the federal, provincial, and municipal governments are Indigenous governments. So we're the lowest in status in the Canadian Federation for those who opt into modern treaties or self-government agreements or this alternative federal legislation. They're maintaining the Indian Act to control and manage us and saying your only way out is those three options, which they've developed unilaterally. And a lot of bands are going for it, the options, because, they want economic development. And as Art Manuel pointed out, if you add up all of the reserve lands in Canada, it's only 0.2% of the land mass. And the rest is controlled by the provincial and territorial and federal governments. And that's one of the issues, is the land base needs to be expanded. And the jurisdiction over that land base, the right of self-determination over that land base needs to be recognized. But that's not what they're doing. All the legislation they're passing is based on their 1995 inherent right policy, where they say they recognize the inherent right, but then they put limits to it. And then when you opt into negotiations under that policy, you're agreeing to the preconditions, to your inherent right or self-government. And that's what they've been doing. Even the Child and Family Services Act, they're basically imposing, the federal jurisdiction in that area. And even if you didn't agree with Bill C-92, the legislation, as soon as you opt into it, you're consenting to federal jurisdiction in that area. And the first recommendation the Royal Commission on Aboriginal Peoples made in 1996 was for governments and courts to stop relying on the doctrine of discovery and terra nullius. Now, the Supreme Court has said terra nullius doesn't exist in Canada, but I would argue that the Chilcotin case was in British Columbia, so they were looking at the Royal Proclamation. But if there was a case that came out of Quebec, Quebec has a different legal tradition from, French Napoleonic law, which became Quebec civil law. And they viewed Quebec as empty territory inhabited only by savages or infidels. So I would argue that they would have said that terra nullius applied to the territory that they were asserting. But that hasn't come before the courts yet.
An interesting aside on that, Russ, around the issue of terra nullius. I reviewed my great-great-grandfather's papers as part of the Dominion Lands Act process. He and his family of 5 kids under 12 and his wife showed up in Saskatchewan and signed a piece of paper where they said they acknowledged that there is no one who lives or occupies on that land. And so they actually got individual farmers to sign off on terra nullius, which is a little bit outrageous, but that has also never really been tested. So I think there's some research that settler community can do to do a little bit of that work. Look at our own, we're only 2, 3, 4 generations for most of the land gathering. Most of the
Those are all treaty lands.
Yeah. And so, and yet my father tells the story of when he was a child, a family would show up each season to gather bones. And then one summer the son that he played with was just no longer there. And that was a residential scoop. So I think that some of the capacity to support some of these arguments are tied up in people's family histories or their own property accumulation and reporting on that. And I think settlers could do a really helpful piece to explore and share that history. The other question, Russ, is folks are asking, what can settlers do? Okay, go ahead.
Well, before you ask that, I really find it offensive that these church groups, human rights bodies, the unions have all supported Bill C-15 because AFN and the other national Indigenous organizations do. They don't care that Indigenous peoples in the communities, the rights holders, were bypassed and that this is being done during a pandemic. I find that really offensive because, it's a typical Canadian white response, though, no offense. But I find that, they think they know what's best for Indigenous peoples, many of these groups who have ethnocentric views. if not racist. And you know, that's something I hope we challenge more, is asking them what's their reason for supporting Bill C-15, you know, other than just because some of the Indigenous leaders are doing it. You have to remember that basically it's mostly the Indigenous elite class that are supporting this. They're well funded by the federal government. And it's also groups who have signed modern treaties or self-government agreements that have defined their Section 35 rights. So they don't have anything to lose by supporting Bill C-15 because they've already compromised their Section 35 rights by signing agreements under these policies that the government came forward with. It's the Indigenous communities and nations who haven't agreed with these policies and have unresolved Aboriginal title and rights or treaty rights issues, you know, that are opposing this. And you know, Onion Lake Cree Nation, for example, just sent a letter to the Prime Minister and put out a press release saying they're opposing this. And I understand more chiefs are going to be coming forward saying they're opposing Bill C-15 too. The way it was developed, you know, bypassing them as well, and doing it again during a pandemic. So I think you're going to see more opposition coming from First Nations leaders. And Perry Beauregard, you know, he may not be worried about it because he's not running again, but it will become more and more public for the Trudeau government that there is opposition to Bill C-15 amongst First Nations. And as it gets more public and publicized, all of these church groups and human rights groups and the union, I forget what that organization's called that represents Unifor and all of them. There's an umbrella organization. Oh, the Canadian Labour Congress. They're supporting it. And they represent all the unions. And of course, many of the unions represent workers who work in these resource extraction industries that are on stolen Indigenous land. So I think, you know, for Canada, we have to, Bill C-15 gives us a teaching moment, as you can say, to show the history of Canada, because Trudeau wants to rush to reconciliation, but he wants to bypass, you know, getting to the truth of what's not happening. And even the Commission on Murder and Missing Indigenous Women have said it's genocide. That's ongoing, it's current, it's not past. And that's what Canadians have to come to grips with, I think, is the fact that they can't say, oh, it's a historical thing. It's not a historical thing, it's happening today. And it's structural. It's structural colonialism and racism. You know, there's talk about systemic racism, but they're not talking about systemic colonialism, you know, right into the Constitution, right into, you know, the Supreme Court decisions. So I think Bill C-15's opened up all of these issues because it's equivalent to, you know, the constitutional process that happened in the 1980s. The implications of Bill C-15 and international law applying to Canada on the rights of Indigenous peoples is massive. You know, if you look at all 46 articles, including the one where Article 46, where, you know, they're claiming you can't challenge, you know, Crown sovereignty or territorial integrity. I would say you can. I mean, I think it's our birthright as an Indigenous person to challenge that. And I think it's even in the anti-terrorism or in the Terrorist Act, Bill C-52. That they're saying that you can't challenge the sovereignty or territorial integrity of the state. But as Indigenous peoples, I think we definitely have a birthright to do that. These matters are not resolved.
Indeed. I'm noticing that we're getting just a little after 1. I have one further question for the folks both on this call and out in the larger world as we move through our discussions with other people who are moved by the case you've made, Russell. What could folks do? What can settler folks do to support your, I don't want to say team, to support the folks who are working to oppose this bill for the reasons that you've laid out in this call?
Well, we're going to continue our campaign to stop Bill C-15. They can support our campaign. I think there's kind of a two-pronged approach to that. Our campaign, one is to get to our people in our communities and nations. We definitely want to document their opposition to this. But I think non-Indigenous Canadians can support our campaign by going after the Prime Minister, the cabinet ministers, particularly Lametti, Carolyn Bennett, Mark Miller, um, the Minister of Northern Affairs, and the MPs, the leaders of the parties. I don't think Jagmeet Singh, I've been critical of him right from the beginning when he made himself, the critic of Indigenous services and Crown Indigenous relations when he knows nothing about our issues. In fact, he was absent during the whole invasion of the Wet'suwet'en territory. He only came out after and made basically a weak statement. And I would argue the federal NDP are closely tied to the BC NDP. Two of the former MPs, federal MPs, in the NDP caucus of Jagmeet Singh's are now cabinet ministers in the Horgan government. Murray Rankin is the Minister of Indigenous Services, so he had just left being a federal NDP MP to becoming a cabinet minister as a result of the federal election. The provincial election in BC, where they have a vast majority, I think 56 seats out of 80. So they have a massive majority government, and Premier Horgan was arrogant to begin with. I think on Indigenous rights and his interpretation of that Bill 41, he's going to be even more arrogant. So I think, non-Indigenous Canadians can help support our campaign in different ways, because we aren't going to be stopping. We're going to be doing, public presentations and probably, maybe public demonstrations. We'll have to see what can be done during the pandemic, but we definitely will be active. So any support we can get from the outside, and also maybe question some of these religious orders and human rights groups and the Canadian Labour Congress as to why they're supporting this bill when there's opposition to it. And hopefully we'll be able to demonstrate our opposition in more concrete ways to show that, Perry Bellegarde doesn't represent our views.
That's great. So the one last question is, folks are wondering, you mentioned one book at the beginning that deals with the United Nations Declaration. Are there other books that would help settlers build a better background knowledge, whether that's on the Section 35 constitutional interpretations or some background on that? Are there any other books? I know definitely your book, The Decolonization Handbook, is one that I always recommend. That's
Yes.
a co-authored book.
Yeah, that's a free downloadable book. The Decolonization Handbook. But I always recommend Arthur Manuel's books, because Arthur did a great job. He's got a book called Unsettling Canada, which is kind of a history or a biographical history of his political life, growing up under his father, which was George Manuel. And George Manuel, they just reissued his book called From Brotherhood to Nationhood. That gives a good history of the modern political and Indigenous rights movement from the 1960s and 70s. He created the World Council of Indigenous Peoples, so he created the first international Indigenous organization, George Manuel. So Arthur Manuel also has a book called The Reconciliation Manifesto. Arthur was long enough to see the first year of this current Trudeau government's so-called reconciliation process, and his view immediately was that it was fake reconciliation, and I agree with Art on that. But his books are really important to read because he has a very good perspective, because he did a lot of international work. Art and I kind of had a division of labor between us, when he started the Indigenous Network on Economies and Trade and focused on international work. He didn't bother with Ottawa. He was in New York and Geneva and going to different UN forums and traveling to different countries globally to meet with Indigenous peoples and that. Because there's 370 million Indigenous peoples around the world in over 90 countries. So, we share a common history with them. And, Art was keeping up with them. So he would focus on the international goings on, and I'd focus on the domestic situation and keep track of what they were doing on what I call their national termination plan through domestic policy and law, like Bill C-15, which I think is the final nail in the coffin of what Trudeau's been doing for the last 5 years and before. So I think those are some of the books, you'd want to read. People from Terra Nullius by Boyce Richardson,
Mm-hmm.
a close friend of mine who just passed away not too long ago too. That's a good read if you can get a copy of that. So there are different books if you want to know the history of the relationship. Arthur Manuel's book, George Manuel's book, Ron Derrickson, Grand Chief Ron Derrickson, who co-authored with Art Manuel, just put out a book called Fight or Submit. And Ron was, he's a successful businessman, but he had to fight the system and the racism and everything. His book is interesting, to talk about everything he had to overcome. And him and Art were very good friends right up to when Art passed away. So there are books to look at that will give you some insight into the background to this fight that we're seeing going on now.
Great. And then as a general move going forward, I will sort out how folks crashed my Zoom account. We're going to have this space open every Tuesday, noon to 1, to have teach-ins. And so we can either do self-directed learning as settler to settler education. Periodically, we'll bring in esteemed guests like Russ to bring us up to speed on perspectives from Indigenous perspective. And when all else fails, we'll play a little video and then have a self-educating discussion after that. Another opportunity for people who want to get into doing some reading and really get up to speed. On Twitter, Daanis, follow Danis. That's Anishinaabe for daughter. She has a website where she's posted, she's doing a year-long book club as an effort to try to help, because it gets really tiring arguing with people in Twitter who don't know what they're talking about. So I think she has an interest in helping us Canadians, settler-descended Canadians, be less propagandized by our upbringings about what's going on here. So with that, Russ, do you have anything else that you want to add?
I would just add that we did do a full analysis of Bill C-15. It is on a website on, I don't know, Moore's page, but also if you Google my last name with Bill C-15 and UNDRIP, you'll get the media co-op page, which also has it there where you can download it, our full clause by clause analysis. So if you really want to dive into it, I would suggest you download that document.
Sounds great. Are there any further questions before we wrap up? I'm having people say this has been incredibly useful. Thank you so much. Thanks all. I've read Unsettling Canada, Decolonization Handbook with an exclamation mark. This is great. I really appreciate everybody's engagement here. I know we're a small group due to the having to leave, but appreciating everyone's time. Being online extra is hard in a pandemic when many of us living online a lot. Miigwech, Nyawa, Russ, and we hope to talk again. Yeah, and if you feel like there's a benefit in a follow-up, if there's a shift in the action that's happening and a call out to settlers, please do let us know, and we'll let that information extend onto the Land Back Party website. And it's always a joy to hear directly from a knowledge keeper. And so thank you again.
Yeah, thanks. We'll stay in touch.
Sounds good.
Thank you.
Okay, bye everyone.